Hi, this is Ed Amoroso from TAG. Welcome to our webinar. We've got a great discussion today. We're going to be talking about incidents in the SEC and reporting. We've got some real experts here. I think you're going to enjoy it. We have Randy Milch, who has a long career in this area, is over at New York University now, and is just a real expert. Chris Hetner, who I've known forever, who knows as much about this topic as anyone I know, including having some considerable experience with the SEC. And Andy Lunsford's our resident entrepreneur here, who's building out a platform that kind of works in this area a little bit. And we're going to ask him to kind of show what are people actually doing here. So we've kind of got a little bit of academic, a little government, a little bit of entrepreneur. And I'm going to play the role of your dumb moderator. Occasionally I'll ask some sort of dumb question. Being a moderator is good because you can make believe you don't know the answer, and if you really don't know, nobody knows the difference, so it works out nicely. But I'm going to ask the guys to just say a couple of words about themselves, and then we'll come back and let each of them go into a little bit of detail about this important topic that I know is on most CISOs' minds. What are we supposed to be reporting? Kind of what types of incidents report? What are the issues? We'll get a lot of background. I'm going to give the guys some leeway to go in whatever direction they feel organically is the right choice. So, Randy, why don't we start with you? A couple of words about your very illustrious career, and then we'll go to Chris and Andy.
Thank you, Ed, and thanks for having me on this. It's a real privilege, as always, to be involved in the TAG stuff, and you always get great folks. I am now a professor of practice at NYU School of Law and am the co-chair of the NYU Center for Cybersecurity and am the faculty director of our Master of Science in Cyber Risk and Strategy program, which we're very lucky to have Ed as a distinguished professor in. And before I slouched into academia, I was the general counsel and head of public policy at Verizon Communications, where through a series of mishaps, cybersecurity was one of my responsibilities. Of course, this was back in the day when it was far less sexy to be involved in cybersecurity. And so that's my background, Ed.
Thanks for being part of this. It's going to be fun to hear your thoughts. Chris, a couple of words about your very fine career.
Hi, Ed, and great to be here amongst such an esteemed group. I'd say probably we've had one of the most eclectic careers in cybersecurity, starting early days in the early 90s, studying the intersection between criminal behavior and computers. John Jay College, Criminal Justice, City University of New York. Spent the balance of the 90s building out and operating data centers, which I know, Ed, you very familiar with in terms of security operations centers, mostly oriented towards the financial services markets, and then went from the data center to putting on a suit and took a role at Citigroup and ran a large portion of their information security program dealing with regulatory compliance matters for their corporate investment bank. Had the opportunity to go from one boiling pot of oil to another at GE Capital, where we were a SIPI designated institution as per Dodd-Frank, and basically built out their global cybersecurity program from the ground up, became their global CISO. Spent a couple of years in the management consulting arena at Ernst & Young, addressing cybersecurity matters for SEC registrants, wealth management firms, private equity. And that took me to an interesting opportunity to go serve as senior advisor for cybersecurity policy for both Mary Jo White and Jay Clayton within the chair's office. Right now, back in the private sector, collaborating with leaders such as Ed and Randy and Andy on matters of cybersecurity, largely operating with the boardroom community on cybersecurity risk governance, as well as areas of risk management, particularly around the new SEC rule, and as senior advisor to the National Association of Corporate Directors. We have a portfolio of about 23,000 members where we deliver insights, we offer certifications, and then more recently advancing a cyber risk governance and reporting platform that's been selected by our members that aligns very nicely with the new SEC rules and other governance requirements. So I look forward to the conversation, and thank you again for having me.
At some point, Chris, when we're looking for the next cyber czar, you have my vote. You got the right background for that. So I don't think I wish that job on anybody, but if you'd certainly have the right background.
It appeals to my ADD, so I have to make sure I'm spread and establish that 360 view.
It's fun to hear what you have to say. Andy, tell us a little bit about your work.
Yeah, thanks. Great to be here today. Yeah, Andy Lunsford, co-founder, CEO of BreachRx. I come from the legal world as well. I started working in data breach litigation in the early 2000s, so a little over 20 years of experience in cybersecurity litigation. I also spent a stint in-house at Walmart's general counsel's office, did a lot of compliance work there as well. But BreachRx, our whole goal is to be a company's incident management program business-wide. So not just security, not just legal, but the whole company and how they can manage an incident. And what's specifically relevant for this conversation is that we do a lot of things to help minimize liability for a company when they're going through an incident, and also protect people individually. So I know that's a big top of mind issue for a lot of CISOs today. It's how do I protect myself and how my company handles an incident. And at the end of the presentation, we'll show a few ways that our product can do that for people.
You and I had been talking before the SEC stuff came up, and you were one of the first persons I called and said, whoa, this looks like this was written for you guys. It's like, I kind of fell in your lap. You'll have to show us, because a lot of the discussions, like Randy and certainly Chris, we're always involved in these discussions. They're very theoretical. So I think it'll be fun to actually see in your mind, where does the tire hit the road? Like, how might someone actually do this? Because I've been a big proponent of finding ways to automate this. Randy's heard me go off a number of times about how, if you're going to do this, you better automate it. And you'd shown me something that I hadn't seen. So Randy, why don't you set the stage for us? We'll start with you. Give us the, you put on your professor's cap and teach us what's this all about, and then we'll go to Chris for his guidance on what, where a lot of that came from.
And I'm really happy that I have Chris here, because it's always good to have someone who is in some ways responsible for these sort of things when he was in his government.
We can blame Chris for this whole damn thing.
So
that's okay. I'm a big boy. I can take it.
Yeah, we know that. What we're operating under here is a set of rules that the SEC finally implemented in the summer of 2023, the summer of last year. Prior to these rules, the SEC had in 2011 and in 2018 issued various types of guidance to public companies. So we're looking at companies that are public, that is, their stock is traded on one of the exchanges. And there had been guidance issued in 2011 and 2018 with sort of increasing urgency, as you could imagine, essentially reminding public companies that they had obligations, pre-existing obligations, to disclose so-called material events. And you do that on a either periodically in disclosures, annual reports, quarterly reports, or if it's an emergent issue, you do it on a so-called 8K, which is oh my God, we got something going on. The investing public ought to know about it. And in the rules that finally got issued, because I think the SEC sort of felt like just reminding people of their pre-existing obligations and that cybersecurity could be important, they wanted to issue some rules about it, which is a not unreasonable administrative step to take. Included the set of obligations that center around the need to disclose material cybersecurity events, a so-called cybersecurity incident, within a certain amount of time, 4 days, which is short, and also institutionalize rules about the processes and procedures that companies ought to take to ensure that, number one, there's suitable oversight from the board of directors on the process, and number two, that the suitable steps have been taken within the company to ensure that accurate information flowed to the people who are making these disclosures. So that's sort of the set of efforts here. the critical issue of that is one of the critical issues, and it has two parts, and I'll talk about that, is what is an incident? A cybersecurity incident, and on the one hand has a very common set, very understandable to those in the cybersecurity world set of words that deals with an unauthorized occurrence or series of related unauthorized occurrences on or conducted through a registrant's information systems that jeopardizes the confidentiality, integrity, or availability of a registrant's information systems or any information residing therein. Now, stripping away the lawyer words, the CIA trilogy is, of course, very, very understandable to all of us. There are a couple of words that I think that we ought to focus on in this definition. One is the words about series of related unauthorized occurrences. The other one is jeopardize, right? So it's not necessarily a hack, right? It could be something broader than you actually have had information exfiltrated, right? Because if someone's intruded on you, there's been an unauthorized occurrence, as it were, right? And there's a related definition of cyber threat, which is something that may result in adverse effects on the CIA trilogy information. And the SEC, listed many things that stem from cyber incidents as a reason for the operational, reputational, informational aspects of being of a threat. But they were also clear that this is operationalized by the need to have any of these incidents, anything you report has to be quote unquote material, right? That's it's not in the definition, but it's in the operational aspects of this rule. You report material cyber incidents, you report things to ensure that material information flows, et cetera, et cetera. So material is a little bit wishy, a little bit of a squeeze play here, right? The legal definition is any information that would change the total informational risk in a way that a reasonable investor would be interested in, which is
different for smaller versus larger company, certainly, right?
Well, it's always been a play. When I was at Verizon, we always had very rich debates about what was material and what wasn't material. And obviously, for a huge company like you were in, Ed, or I was in, it's hard to find. You need a lot of zeros, let's put it that way, in order to.
$1 billion hit to a $250 billion company may or may not be material, right? It may not.
On the other hand, the SEC was also had interesting language about the need for harm to a company in order to even think about it. But they were also clear that sometimes harm could be delayed, sometimes harm may not be ever appear, and it could be material and important. So companies have never been able to be confident that they've always been able to peg what's material or not material going in. Sometimes you always take a little bit of a risk. Here, I would suggest that the risk factor about materiality has increased somewhat, and I'd be interested in Chris's view on this.
Chris is here for a reason, man. We got the guy here. So, Chris,
but I mean, particularly because of this related incident part of this, and we've seen some of this come to fruition, I think, in the SEC's fraud case in SolarWinds, right? And I think that if we have a chance to talk about that, you see the SEC's attitude, in my opinion, in action a little bit there, and the way they have grouped together items, the way they have talked about even things that in isolation they agree were non-material. In group, they are material, and what you would say and how you would do that. I think that's all very interesting. But that's sort of the baseline, Ed. I hope that's
a good base. Chris, take us through your thinking here. You've been involved in this and you've been observing. You've seen this from every different direction. What are your thoughts on the issue?
Yeah, so really, again, just full disclosure, I am not an attorney. So I was the anomaly in the chair's office, the one office that had technical network diagrams and, flows around threat intelligence, how that informs the SEC's policy rulemaking processes. And, we had the pleasure to work very closely with the intelligence community, with the White House, U.S. Treasury, as to how cyber threats could undermine the U.S. securities market. So really, let's take a step back here. There's really two intentions here. Number one is surrounding elevating cybersecurity as an enterprise risk management matter, as a effective way to govern this capability all the way upstream to the board of directors. I work very closely through the NACD community with specific law firms underprivileged, understanding how they think about cybersecurity risk management, governance, reporting to the board. There's a whole discussion around materiality. What are the types of playbooks that exist? And I will tell you, just working with some of these companies now for the last year or so, there's a significant disconnect between the inner workings of cybersecurity within the corporation, how it flows upstream to the general counsel, particularly around a determination around materiality, business impact, and flow upstream to the board. So the intention, number one, and this particularly is reflected through the 10K disclosures, is to project and disclose how you exercise cybersecurity risk management practices, how this is pivoted into the board of directors. And the way I advise our boardroom community, it's about the frequency and the touch point between management, and I would include the CISO, but I would also pair that with the CFO, the Chief Risk Officer, General Counsel, as a collective unit talking about cybersecurity. It's about the substance of the discussion with the board. So it shouldn't be a 30-minute annual discussion with the board, highly technical report, you're in, you're out, 0 questions and engagement. That is not what is intended here. It's supposed to be about substance and engagement. There's also discussions around, do you have competency on the board of directors? How do you augment some of that capability? I know they stripped that requirement from the rule, mandating that you disclose whether you have a quote unquote cybersecurity expert on every board, but they want to know how you exercise that oversight in terms of enterprise risk management all the way up to boardroom reporting. What's the right committee? Is it embedded into audit committee? Is it embedded into the risk committee? Some best practices suggest that there should be a focus group within the risk committee that is complementary to cyber, such as how do we adopt advanced technologies such as artificial intelligence, supply chain risk management, dependency, geopolitical risk, privacy, data privacy risk. So it's all very complementary in terms of how it's overseen within that committee, and then perhaps it's reported on an annual basis to the audit committee. So it's really projecting how this is governed as a systemic risk across the corporations. Then through the lens of the 8K is when the proverbial X hits the fan, right? We're in the night fight. We have an event. I've been privy to many cyber incidents, and by the way, they always happen on the holiday or on the weekends. And I'm on a call with our general counsel, with our security operations team. We've got APT actor XYZ. How do we get them off our network? Which is why I lost all my hair as a global CISO. And it is a night fight. It's very stressful, and it's the human factor comes into play where you start losing perspective, you start losing structure around process, and so the SEC is really pivoting towards how do we create more structure and process around this. And the materiality question, I think historically has been squishy, and I think it's starting to crystallize a little bit, but I'll walk you guys through at least some of my thinking on this, particularly as we set the foundation within Jay Clayton's office around the 2018 interpretive guidance around this matter. So the materiality determination is really ultimately influenced by the incidence impact. And again, incidents come in all shapes and sizes. It could be ransomware, it could be intellectual property theft, it could be personal identifiable information loss, it could be human error, right? And by the way, through our NACD reporting capability, last year suggested that 50% of cyber incidents were introduced by human error. But at the end of the day, in order to reflect how this is impacting the investor community, it's really about how these incidents impact the company's business, operations, and financial condition. And the types of costs and adverse consequences that a company may incur or experience are starting to come to light, particularly through the risk transfer markets, who I've been working very closely with to think about how the insurance industry is starting to price and project how cyber risks are occurring. So I'm just going to enumerate some examples.
Please.
So number one, a cyber incident may introduce costs due to a business interruption event, decrease in production, delays in product launches. Think about companies that were in the gaming industry last fall that had various types of business interruption outcomes as a result of a ransomware event, and therefore their payment systems were down, their online booking systems were down, their gaming platforms were unable to take cash and credit card in order for them to produce revenue. We see this also in manufacturers that see significant business interruption events. I could think of Hanes brand that took a $100 million write-down as a result of a delay in producing product to market because their manufacturing systems were down. Another example was Clorox. Clorox had another event that delayed in product launches. So these are true costs that are being incurred by these corporations. We can't ignore the payments introduced by the ransom or the extortion demands, although they're not necessarily material relative to the downstream business interruption impact, particularly within a ransomware type of scenario. There's also the remediation costs, such as stolen assets, information, repairs to systems. Now I've got to rip and replace 30% of my network because these systems have been, quote unquote, bricked as a result of a destructive type of malware event. What about the incentives to retain customers or business partners, the counterparty exposure? So suddenly I'm out of business for 2 weeks. I have counterparty risk exposures that I have obligations to address and maintain those relationships after an attack. There's also within the insurance industry, the increased protection cost or the cost associated with increased premiums, the cost of making organizational changes. What about the regulatory implications? Now you're reacting to regulatory enforcement actions that is forcing you to command and deploy resources and personnel, engaging third-party experts and consultants. I can think of my days back in corporate America, the loss of revenues resulting from intellectual property theft. We see this in the big pharma industry where you have the latest and greatest cancer treatment drug. Suddenly the Chinese government comes in, extracts 30% of that intellectual property. How does that impact your go-to-market strategy? How does that unauthorized use of intellectual property or failure to retain or attract customers as a result of the attack? And of course, Randy can speak more closely to this. The law firms are very active, right, in supporting class actions and litigation, regulatory actions. I mean, some of these regulatory actions as a result of failure to tend to the garden around maintaining cyber hygiene practices, that can be in the billions of dollars. I can think of, the all-in cost associated with the Equifax breach was roughly $1.5 billion. And then, of course, there's the harm to employees and customers and violation of privacy laws. And of course, there's always a question around the cyber event impact on the company's competitiveness and the stock price. But historical views suggest that the stock price rebounds. But during that time period, there is potential loss in shareholder value. So the reason why I try to reinforce these principles it's not about the SEC commanding the registrants to disclose how the unauthorized action occurred, what vulnerabilities were exploited, but ultimately, what are they doing to deploy capital and resources in order to avoid or manage down these downstream operational, business, and financial impacts that were just enumerated before?
That's such a comprehensive view. I couldn't be more appreciative of the density of this topic. I mean, you can go on and on and on with this thing. The more you peel, the more interesting it gets. But Andy, let's talk to you a little bit. You're our resident entrepreneur. I'd like you to talk a little bit about what you're dealing with in talking to actual live teams dealing with this incident reporting challenge. I'd asked you, I know you didn't ask, but I'd asked if you would show some screens and just show us something that we can actually see instead of just talk. I'd like to show some things that people can see. So if you wouldn't mind, I'd like you to pull up a couple of, whether it's screenshots or something that just gives a little bit of grounding, but talk a little bit about the kind of support that you're providing. I've been a big proponent of, you really need to find ways to automate, because CISOs should not be following human manual processes around this. There should be dependable, automated, reliable, repeatable mechanisms that are used here, because that's the only time I wouldn't be able to sleep if I didn't have something that was at least providing backup. So share with us how you guys support some of that.
Yeah, just to add a few things into what Randall and Chris said, there are 200 plus cybersecurity regulations around reporting across the world. So SEC is just the latest one that is kind of fever pitch because it applies to all public companies. And I think, it's important to note a couple of things that were part of what both Chris and Randall said that has been super impactful on customers, especially publicly traded customers of ours. And that is that the definition of a cyber incident and the materiality, largely, if you read all of the commentary around it, they don't talk about personally identifiable information as being a major trigger. And so most of the 200 plus regulations we've seen to date, that's usually the tie. Is like, okay, was there some kind of personally identifiable information exposed? That's going to start these ticking clocks for how quickly you need to notify. This is a case where that's no longer a part of that. It's just about having a material cyber incident. And so there's a whole portion of publicly traded companies and companies at large that have kind of ignored a lot of these laws because they'll be like, hey, we don't hold a lot of personal information, so we don't need to necessarily pay attention to all these reporting obligations. That really changed with the SEC law, and there's also the federal CIRCIA Act that came through for critical infrastructure that similarly doesn't talk about personal information when it comes to disclosure. And so that's really changed the dynamic a lot for these companies. And so the other thing I would say is that by the SEC formalizing these rules about reporting, the reaction when we talk to general counsels across our customer base and CISOs is that we've moved from a state of you need to report when something happens to these are our incident response records will be audited like financial records. So you need to have it buttoned up to say, hey, this is when we knew something happened. These were the actions we took. We did a materiality analysis at this time. We came up with this result. And oh, by the way, if it wasn't material at first, we revisited that analysis again when we got more facts. And because of this ongoing reporting obligation to the SEC and other regulators, you need to be continually reassessing and potentially reporting throughout the incident response effort, not just that initial 4-day notification. And so I think those are kind of important pieces to note that our customers are very anxious about. And then I think on top of that, we see this personal accountability. And so seeing that, it wasn't part of the SEC rule, but seeing, Joe Sullivan experience what he did where he got held personally liable for how the company handled a breach. And then most recently, as we mentioned before, the SolarWinds CISO also experiencing this, being charged with fraud about this. And so I think a lot of our customers were like, okay, how do I protect myself to show that I was doing the right thing at the right time and I took all the right steps? And a lot of that is having a really solid audit trail. And to your point, Ed, having an automated way to say that we dealt with this in a very quick fashion because we put the systems in place to actually track that. So yeah, I think with that, I'll pull up the product and just kind of show you guys a few things. It's a very big enterprise-wide product, but I think just focusing in specifically on what we do for the SEC, I think would probably be valuable to people to see.
And as you're pulling that up, my observation has been that it's been an interesting opportunity for CISOs and CEOs and their legal staff to either tighten the relationship or maybe meet for the first time, dare I say. So I mean, if you're going to thank the SEC for one thing, man, I think they're in some sense bringing the CISO a little closer to that C-suite, which is a really good thing in most cases. Some cases the CISO is not ready for that, but that'll change over time. So Andy, tell us a little bit about what we're looking at here.
Okay, yeah, so we are an incident management platform for the entire business, and I'll just emphasize that, especially when you think about this kind of SEC reporting, there are multiple stakeholders, and I think Chris touched on this in his comments, and Randall as well. It's not just the security team that needs to weigh in on materiality. It's the chief risk officers, the general counsel, the CFO. There's all of these different people that have a say in determining whether something is material, and depending on how you organize yourself as a business, you need to be able to show how people are evaluating that. So yeah, I'm just going to quickly show, kicking off an example incident and how you might face a materiality analysis within it. So pretty simple to kick off an incident. I'm just going to start with a playbook for insider threat as an example here, and yeah, just label it. And so say this incident's happened, this insider threat is going on, and you have an early sense of what the criticality might be. So we'll just say, hey, for example, this one we think is critical based on the access this person has. And I'll kick this off. And so you'll see where the collaboration across the organization happens here once you've started this incident. And that we've started an audit trail, which is another key component here. So you can see we've already got this recent history. I've kicked off this incident. There's a record, a specific timestamp of when I've done that. And I'll skip over here to the actions tab, which is where all this collaboration is happening. And so our platform is dynamic in that based on the kind of incident you have and the facts you know about it, we generate tailored action plan that's specific to that incident. So with this one, we've gotten started. We have the things you would expect in the identification phase of an incident, assess the scope, and notification for insider threat, et cetera. And I can assign these tasks to specific people on my team to work on, or I can accept them for myself if I'm sort of in the incident commander position of the incident. But I think just to zoom in, because we've limited on time on the SEC aspect, first step, can we talk about these kind of two gates? One, does it qualify as a cyber incident is the kind of threshold matter. And then secondly, we'll talk about materiality analysis. So we've taken the commentary that comes directly out of the SEC rules, exactly what the SEC said about interpreting what is a cyber incident. And I think we touched on that before. It's the CIA triad are the fundamental questions you have to answer as an org to determine whether it hits that cyber incident threshold. So this is an initial task for the company to do. And as I make that determination, I will be recording whoever is assigned that task, whoever on the team is working on that, whether that's a security team or in combination with the legal team, they would be entering those details here, and then it's basically recording from a timestamp perspective what they did at that time. And so then I'll move over to materiality analysis, and again, we've gone deep. There's a lot of different, very complex ways people have been trying to interpret, I think, how to handle materiality analysis. You can go into a FAIR model, some law firms are suggesting, but most of our customers find having a more simple way to approach it that is really in their language, in the measurables that matter to their business. That's kind of works best for them, given how fast you have to make these determinations. But we've gone through and said, okay, based on what's in the commentary, these are the key questions that the SEC has asked you to answer about an incident. And they touch on all these different areas that we talked about before. You know, what will it do to the business reputation? How about operations, relationships with your customers and vendors? What does it do from a competitiveness perspective, et cetera? And so all of this is here, and the company is prompted with this is the task to accomplish, and they can enter that activity across that cross-functional team with the timestamps of getting all that work done. Again, so that when you have this Monday morning quarterback effect of, you know, hey, my incident records are being audited like my financials, you say, okay, here you go. You can see with the specific timestamp when we made this determination, what factors we knew at that time, across the different people that are involved. Again, just very important to be creating that audit trail, and I can show you briefly how that reporting looks at the end. But another aspect of this that is vital, I have to say, as an attorney, is how do you manage attorney-client privilege when you're going through that piece? And being living in 20 years of litigation in that space, the non-attorney communications, and even ones that do have attorneys involved that get turned into, that come over in discovery are very problematic. We've purposely bifurcated this activity. So you're creating this factual record here, but say on this task for materiality analysis, you want to have a back and forth as a team strategically. We have this other, you move over to the chat part of this task, and you have a privileged and confidential area that doesn't become part of that report that we generate at the end, which again is vital to protect these communications. They can be sensitive, a little more open dialogue amongst the team, apart from, hey, in these activities, I'm timestamping all the things we're determining. And so you can do that on a task basis, then you can also do that on the incident-wide basis in the conversations part of our platform. And so our customers are finding that super valuable to help them have that dialogue when sometimes it's like, where do I put that stuff? You know, if you do that in Slack, ticketing tool, Teams, all that stuff for a number of court cases we're seeing is just coming into evidence because those tools are for other business purposes versus a tool like ours that is designed for this purpose, has purposefully done this kind of bifurcation, aligns with your policies, et cetera. So that's how that works. Real quick, you have these response reports, just to give you an example of what that clean without the confidential information gets generated. Very easy to go select down an incident that's happened before. So like I'll pick, say an example here, this banking app leakage. It has all the information summarized about the incident, and then it has specific timestamps for when the particular things were accomplished with a long audit trail at the end. And so this becomes a point and click report versus something you're piecing together for weeks after an incident. Super valuable to our customers. The other piece I'll touch on, because I know want to be brief here, is another aspect of this SEC rule is the governance pieces and showing that you have a good program in place. And when it comes to showing you have a good incident management program and that you've operationalized your process to deal with incidents, we've taken all the different frameworks you would have, including Sarbanes-Oxley, but also SOC 2, ISO, et cetera, and we've mapped those incident management requirements to the way our platform's set up. So you can very easily generate an audit report that shows consistently over time your incident management program meets and exceeds any framework that you might be putting your company up against. So one very last aspect, and then I'll turn it back to you, Ed, for maybe some questions on a deeper dive. So we cover that 200 plus regulations that face an organization. So not only do we have the SEC set up that way, but hey, what about something like the Alabama data breach regulation? How do we know when that applies? So we've broken those regulations down by, hey, here are all the conditions that have to be true for the Alabama data breach law to apply, and here are the specific tasks that you need to go out and accomplish if it does apply. And again, you can take those tasks, and we have rules on them as well. So like this AG notification in Alabama, that's not going to apply unless those previous conditions are met, but it's also over 1,000 records. There's a reasonable likeliness of harm, and the work was not done in good faith. So this is just a flavor of this full library you have. And again,
that's very helpful, Andy. I think for people who are watching, I hope they'll be in touch with you. This issue of the states and so on, for Chris and Randy, the things we've been talking about are very U.S. centric, and we can see even in Andy's tool there's a emphasis here on states as well. I'll start with you, Chris. Well, is this something that we see eventually finding its way more international? Like, is the SEC's action here, do we think that's going to catch on in other countries?
Yeah, it's the conversations I've had with the international regulators so far. It seems like they've become a laggard. The SEC in the U.S. tends to lead on these things. But my understanding, and Randy could speak more closely to this, is the Australian government has issued a similar regulation regarding disclosure around cybersecurity incidents and how companies within their securities markets are addressing this concept of effective governance. What does good look like in terms of governance? Yeah. But and then there's also a European regulation, DORA, that is essentially placing personal or potential criminal accountability on boards of directors and executives within European countries. But I'll hand it over to our attorney in residence, Randy, who can speak more competently about this. You're on mute.
Well,
Randy.
I think that, I mean, internationally, we see it's sort of like the States. You see countries trying to leap ahead. Typically, there's the age-old dig about the EU, which is it doesn't make anything, but it sure as hell knows how to regulate something. We saw that quite dramatically in the GDPR, which contains Article 32, which is an article about cybersecurity, not about privacy. People always debate about our cybersecurity and privacy, two sides of the same coin, two sides of different coins. You can take it however you want, and I think it's important to note that Andy's, very interesting tool. Probably the overwhelming number, Andy, probably 90% of all the rules that you ingest and give your clients information about are actually privacy rules, right? They're triggered by some sort of a breach of private information, as opposed to as you point out, and as Chris certainly pointed out, the much more cybersecurity focused, the CIA triad aspects of the disclosure regimes. And Massachusetts has a cyber law, California has a cyber law. Last time I counted, there were 12 states that had something that looked like a real cybersecurity law, as opposed to a privacy law. And those cyber laws turn on, were you taking reasonable steps, which is of course a very helpful thing to look at in hindsight, right? It's as Chris says, when the stuff hits the fan, you might have some debates about whether what you did is reasonable or not. And unfortunately, the tide does not go to the CISO, right, in these incidents. There are lots of lawsuits and the like. So Europe has the GDPR, Article 32, enforced by data protection authorities in every country. Not necessarily the same, in fact, not the same ways of enforcing those things. Australia has taken a leap forward. Something called the Australian Prudential Regulation Authority, sounds pretty Orwellian to me, has put out a whole set of new standards for management and governance. They've put out a nationwide way to sue people over this. The steps, when you listen to the regulator talk, if you've ever been on the other side of this, if you've ever been on the side of trying to implement rules to increase the quality of your cyber hygiene, to get through the myriad steps that you need to do internally to allocate resources and get people's attention, and then explain things to the board and all that, the notion that you have a regulator out there whose approach to this is very much in the vein, at least the way I heard about it, and it could have been the accent, who knows, very much seemed to be in the vein that we're coming to get you, right? We're coming to get you. And so that sent chills down my spine when I just heard the Australian approach articulated. And to be honest, the SolarWinds lawsuit sends chills down my spine, and I think it sends chills down the spine of CISOs everywhere, hardworking ones who are doing their best even in companies that are allocating resources appropriately to this problem. And to Chris's point, the effort to elevate this to a critical risk item for the board's attention, for the risk management attention, that's a valuable effort. The question about whether you need a retributive framework in order to do that, I think, is a separate question. And
coming to get you, I think, is a good theme for us to close our webinar. It seems like a good final thought here. On behalf of our team here at TAG, I want to thank you guys so much. I know none of you are wallflowers. I know, Andy, your team at BreachRx, people want to be in touch with you. I hope they call you and you get a bunch of demos. And Randy, I know you're very active on social and over at NYU. If people would like to engage, I hope they reach out. And Chris, man, you know as much about this stuff as anybody, especially from board perspective. So I hope people will feel free to reach out to you on LinkedIn, and if they have some questions or comments, they can reach out. But once again, thank you guys for joining today. You guys are great. It was a really enjoyable discussion. I think we covered a lot of ground. And again, for those of you watching, we'll see you all next time. I hope you learned something, and everyone have a wonderful day.
Thank you.
Thanks.
Thanks, Ed.